Welcome everyone to the University of New Mexico Law and Mental Health Didactic Series, hosted by the University of New Mexico's Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're really thrilled to have all of you here to join us again today. I'm Anthony Perillo, the Forensic Psychology Training Director here in the University of New Mexico's Department of Psychiatry and Behavioral Sciences. For our talk today, if you have any questions that you'd like to ask our presenter, you can ask them in the Q&A box anytime that you feel comfortable. We will reserve those questions until the end. We are often unable to get to all of them, so just forgive us if we can't get to yours. For those of you who want continuing education credits but are on a tight schedule, you do have to stay for the full hour, but don't have to stay longer than that. We will let you know when the hour's passed so that you don't have. And you can feel free to stay longer for additional questions, but you don't have to. For those pursuing continuing medical education credits, there will be a sign-in sheet in the chat shortly. For those pursuing APA continuing education credits, the link will be posted about 5 minutes on the top of the hour before this ends. There will be a link for a survey that you'll complete. You'll need to open that link before you exit the talk today, and you'll need to save your certificate for the continuing education credits. We don't have copies of those surveys, so you'll need to make sure you save those yourself. The recording for this presentation should be available publicly to you within the week. And as a heads up for next week's talk will be featuring Dr. Alejandra Leguizamo, who will be discussing cultural issues of power, oppression, and masculinity and sexual aggression. But for this week, I'm thrilled to be introducing today's speaker, who will be discussing issues related to limited English proficiency in forensic evaluations. This is Dr. Emma Hamilton. So Dr. Emma Hamilton is a research assistant professor in forensic psychology here in the Department of Psychiatry and Behavioral Sciences at the University of New Mexico. She is also a proud graduate of the University of New Mexico's Postdoctoral Fellowship in Forensic Psychology. She earned her doctorate from the University of Texas at Austin in 2021, has conducted a number of different types of forensic assessments, such as adjudicative competence, mitigation, fitness evaluations, violence and sexual risk assessment, immigration evaluations, and the list continues to go on. Dr. Hamilton has published primarily in the areas of sex offense registration, collateral consequences, and recidivism risk, and has received awards for her work through APA's Division 42, Division 18, and state psychological associations. She has also served as the legislative chair for the New Mexico Psychological Association and is an early career policy delegate at the national level. Particularly relevant to this talk, Dr. Hamilton is fluent and bilingual in English and Spanish, regularly conducts forensic evaluations with Spanish-speaking individuals, and previously developed programming and provided Spanish treatment services in correctional settings. The topic she presents on today aligns with her desire to bring greater awareness to complex issues of language in the legal system and the forensic mental health systems as large. So Emma, Dr. Hamilton, can I just say I'm honored. I'm thrilled to have you present. I can't wait to hear you talk about this, and I'm sure many in the audience feel the same way. I will throw it over to you.
Thank you, Dr. Perillo, and thank you everyone for having me. It's been about a year since I presented at LMH when I was but a lowly postdoc, and so I'm really happy to be back and to talk about this topic. So we'll kind of skip through some of these intro slides here. Let's talk about really the purpose of the talk today. And what I'd like to discuss today is really go beyond a footnote with regard to how we handle language issues and cultural issues in forensic evaluation. So most of us know and are familiar with some of the limitations that exist when we work with individuals with limited English proficiency. So with regard to interpreters and kind of secondhand information that we're getting, limited testing options. And so these are factors that we might include in a report footnote style, and we might feel like we're kind of checking the box for addressing these cultural factors or being culturally competent by doing that. But today I want to take a deeper look and consider how an individual's linguistic background and as a function, cultural background can and should be incorporated into all aspects of the conceptualization of that individual, to the extent of even forming the psycholegal referral question when appropriate. So I'm going to focus on Spanish speakers today, but I hope this talk also does have relevance to other groups that are limited English proficient and that present in the forensic system. Just an aside about me, as Dr. Perillo mentioned, I do speak Spanish and conduct evaluations with Spanish speakers, but I'm not a native speaker by any means. And, ideally someone would be presenting on this issue and probably has and will in the future. But I'm going to share my experiences and also recognize my limitations with regard to knowledge on this topic, particularly in the aspects of cultural brokerage or having that cultural background that can help bring greater interpretation into language issues. But as we all probably know, there's a massively rising rate of Hispanic and Latino individuals in the United States with varying levels of language proficiency and preference. And it's been estimated that thousands of Latino or Hispanic individuals are Mirandized each year, which is an area of forensic evaluation that we'll be discussing today and has particular relevance when we think about language issues. And as I go on and discuss these topics, I'll be referencing an illustrative case study. So I took pieces from different evaluations in the past to help apply and contextualize some of the content of this presentation. So just briefly going through the agenda today, first we'll talk about some ethical aspirations when working with clients who are limited English proficient. We'll talk about what the research says in terms of forensic evaluation and specific and unique considerations when working with limited English proficient clients. We'll take a deeper dive into limited English proficiency as being salient to the forensic referral question in a number of different evaluation contexts. So adjudicative competence or competence to stand trial, Miranda evaluation, and mitigation. And then we'll talk a bit about recommendations and food for thought going forward. All right, so just some more disclaimers before we get started. The definition of limited English proficient, or LEP, which I'll tend to refer to going forward, it refers to individuals who do not speak English as their primary language and who might have a limited ability to read, speak, write, or understand English in any kind of form. And, it's really impossible to divorce language and culture, but my aim or my goal today is to talk about language really as this key that unlocks opportunities, contact experiences, and privileges, and really shapes the individual's life experience. And, as I mentioned, the aim is to take a deeper look at LEP as really informing the answer to the forensic referral question, or at the very least, enriching our conceptualization of the person across the desk from us. And as I go today, we'll be talking about Miss Garcia, and she's going to be our case study that we're going to be revisiting throughout the presentation today. So Miss Garcia was referred to me for a Miranda evaluation following a charge of child neglect resulting in death. She is a 32-year-old self-identified Hispanic woman who emigrated from Mexico to the United States and has been in the United States in the southern region for approximately 15 years. She has extremely limited English, but she's self-proclaimed to be better at understanding English than speaking. And I think this is an important thing to note because I've noticed, at least anecdotally, that some folks will say similar things. They'll say, I can understand, but I can't speak very well. And it can kind of lull us into a false sense of security with regard to their level of English. And so it's always important to, make note of that when folks say that, but not trust it very much. And really, if their English is not at a level to understand the processes of the forensic evaluation, it's always good to be sure and get an interpreter if needed. But back to Ms. Garcia. So she was in the United States for a long period, 15 years, as mentioned, but she did not achieve fluency in English for several reasons, which will hopefully become clear as we proceed today. She grew up in extreme poverty, and she was working to help support her family, her mom, dad, and several siblings from a young age. So she finished the equivalent of grade in middle school, so like about the 8th grade in the US, which was 5th grade in Mexico, and again worked at a young age. So school was really secondary. She married at age 15 and emigrated to the United States with her husband, who was years older than her. I think it was about several years older, at least 5 or 6. And she had a verified history of physical and emotional abuse by her husband. He kept her isolated. He prohibited her from working or getting an education, which was very notable as she moved with him to the United States and didn't have an external support system. And her marriage really deteriorated with the birth of her first child, who was a son born with physical disabilities, pretty severe physical disabilities, and he required care. She was blamed by her husband for her child's disabilities, and the abuse intensified and culminated in the miscarriage of a second child. Eventually, Miss Garcia was able to leave her husband and move in with her sister, who had also immigrated to the US. And she really was part of a close-knit family and relationship with her sister in the US. They lived on kind of an isolated compound and really only interacted with one another and immediate members of the family. Miss Garcia engaged in solitary work, basic housekeeping and cleaning, and her living situation progressed to be several children in a small home, many of whom began working or holding adult responsibilities at a young age, which mimicked Miss Garcia's experience in Mexico growing up. And she engaged in efforts to get care for her eldest son, which was sometimes successful and other times stymied systemically. But it eventually really fell on the second oldest child to be the one to care for the eldest son with disabilities. Miss Garcia was able to maintain her native language due to the environment of Spanish speaking in the region, as well as her real isolated manner of living. She engaged in significant self-isolation. She had a healthy or normative mistrust, one might say, kind of an attitude of not seeking help following this abusive relationship, and possessed the sentiment that she should not let others in, not trust, not seek help. She can manage on her own. Referenced cultural values of maintaining, overcoming, trusting God to provide. And this was really compounded by her inability to communicate in the English language as well, and fear of repercussions related to deportation that supported her decision to self-isolate and kind of maintain on her own. So as I mentioned, she was ultimately charged with child neglect resulting in death, as her eldest son, who was born with physical disabilities, died in her care, and there were signs of physical neglect. Miss Garcia confessed to the crime or aspects related to the crime in the interrogation room, and the attorney was seeking an evaluation to assess competence to waive Miranda rights. Other information of note: she had no prior criminal history in Mexico or the United States and no history of CPS involvement. So consider your first thoughts when hearing this case. What types of information have caught our attention? What are our first considerations or thoughts when we learn that she is predominantly Spanish speaking? And how do we plan on approaching the evaluation? Are we going to be able to give our standard testing battery, or do we need to make some modifications? So let's talk about what the ethical code and guidelines tell us in terms of approaching evaluations with LEP individuals. Depending on, your ideology and the referral question, we likely want testing to be a part of our evaluation. APA ethical standards indicate that psychologists should consider an individual's cultural and linguistic background, as well as other situational factors, both when selecting assessment instruments and when interpreting their results. So that's something we want to keep in the back of our mind in guiding our approach. The specialty guidelines in forensic psychology go a bit further. Forensic practitioners use assessment methods that are appropriate to an examinee's language preference and competence, unless the use of an alternative language is relevant to the assessment issue. For example, in a Miranda evaluation, if the evaluation, or if the Miranda warning, pardon me, was provided in English, we want to assess their level of English understanding, comprehension. Beyond the issue of testing, which might be resolved by a footnote or a sentence or two justifying whatever approach we decide to take, the specialty guidelines recommend we go further. So, forensic practitioners consider the boundaries of their expertise and make an appropriate referral if indicated, or gain the necessary training, experience, consultation, or supervision. So this begs the question of whether language proficiency of our client falls within the bounds of our expertise. Is referral out or consultation necessary? Oftentimes, referral is not an option because the number of Spanish-speaking forensic psychologists are very few. As such, forensic practitioners strive to understand how factors associated with language or other relevant individual and cultural differences might affect and be related to the basis for people's contact and involvement with the legal system. But I'll take that a step further and say that when forensic psychologists intentionally illuminates linguistic and resulting cultural factors that influence the individual's background, functioning, etc., the legal audience derives a better understanding of the various factors that impacted the assessment results with regard to the psycholegal question at hand. So let's switch gears and talk about what we readily know in terms of the logistics of forensic evaluations with limited English proficient individuals. So language can influence the course of the evaluation. It can and does influence the course and whether the evaluation takes place at all. So oftentimes practitioners who feel unprepared or hesitant to conduct evaluation with LEPs will engage in case refusal, either resulting from self-reflection or because the preparation needed in terms of interpreters, consultation, research, purchase of testing materials might feel too daunting. Consequences from case refusal can result in delays in the case being conducted or seen through, longer periods for the defendant waiting in jail for an evaluation, or the case potentially going to another practitioner who might be similarly unprepared but less self-reflective in their expertise. And a very interesting article by Varela and colleagues from 2011 found that attorneys were actually less likely to refer Spanish-speaking defendants for evaluation to begin with. And as a related finding, attorneys were also more likely, although to a lesser degree, to rate a Spanish-speaking defendant as less mentally ill than an English-speaking defendant. And this is really surprising because communication is the crux of the attorney-client relationship. And often when there's poor communication or impediments in communication, that's the main reason for referral for competency. So that really begs the question, or kind of leads us to think that perhaps attorneys know that these evaluations take up more resources that are not available. And does it seem like too much work to make the evaluation happen for Spanish-speaking individuals? And for clients whose level of English is not at the level needed for provision of accurate, good information in a clinical interview or testing setting, interpreters are often used. But interpreters are not always up to the standards needed to gather accurate information as well. And so sometimes interpreters are ad hoc, meaning they're a person who's not trained, but they're called on to interpret. And this happens often, and spoiler alert, also took place in Miss Garcia's case and with regard to her interrogation. So even if we're not directly engaging in the utilization of ad hoc interpreters, think of how this could have happened in terms of the collateral information or records that we're receiving. And another consideration is whether our interpreter is engaging in mechanistic or cultural brokerage interpretation. So if they're, engaging in mechanistic interpretation, which is kind of more robotic translation, consider the heterogeneity of dialects within the Spanish language. Interpreters who have some experience in cultural brokerage are able to provide additional cultural, kind of unspoken nuances with regard to the information being provided, but each might have its own benefits. So if we're evaluating someone who has disorganized speech, mechanistic translating might be more useful, rather than having an interpreter kind of take it upon themselves to try to translate or make sense of the disorganized speech. And in terms of the certification of our interpreters, do we want someone who has a background in legal or court interpretation, or someone who has a background in mental health interpretation? There's pros and cons in certain situations. And for competency, for example, it would likely be useful to have a legal background and someone who knows what terms to use and has that specialized vocabulary. In terms of testing options, like I mentioned, we're limited. So we're really not supposed to be translating any measures on our own whim. And if we do, they should be field tested. We need to establish evidence of internal consistency, retest reliability, and the scores on our adapted measure should be restandardized for the target population. Using the norms from the original instrument can yield invalid results, as we hopefully know. And some of this work has been done to create different forms for Spanish and other languages, but it can really feel like a Herculean effort sometimes. Even the test of memory malingering, the TOM, which is fairly language free, has undergone studies into establishing norms with Spanish speaking populations, but there's still cautions regarding its use. For example, the dialect used, the location of the individual, and the origin of the individual tested have all been noted as contextual elements that can influence the generalizability of the norms established. And there's also an interesting body of literature. I won't get into it too much, but regarding cultural influences on response style in terms of personality testing. So research has indicated that, individuals from Latino or Hispanic backgrounds tend to score higher on scales of minimization or positive impression management when compared to individuals from Anglo backgrounds. And I won't get into the reasons why, but it's a very interesting research into that finding. And all of this is really to say that without adequate consideration of linguistic factors known to influence the assessment process and its findings, we're cutting corners. And forensic evaluations with LEP individuals is really ripe for unethical behavior in this way, because viewing these and other factors as logistical barriers can result in ethical sliding, particularly if the person has few or no people around them who speak their native language and with whom they can communicate concerns. And even what we've just discussed are really ways to kind of account or control for language, footnote style, going back to the title of the presentation. But it's really taking this view of seeing LEP as a problem to be resolved. Instead, there's a shift toward talking about enriching forensic evaluations by comprehensively assessing for and incorporating linguistic and cultural background and reality of the individual into our formulation and when answering the referral question. And in the seminal text by Melton and colleagues, Psychological Evaluations for the Courts, the authors frequently highlight how we as forensic examiners and report writers are encouraged to consider cultural influences in any forensic opinion formulation and clinical conceptualization. So let's think about our clinical interview, the crux of the forensic evaluation. Much of the information we gather is obtained from what the client communicates and how it is expressed. And for LEP folks, we might rely on nonverbals to a greater extent. For Spanish dominant clients communicating in their non-native English language, so bilingual individuals or those whose language abilities are good enough to participate in the evaluation in English, there's some important findings that can directly relate to our observations and then our clinical conclusions. So Spanish dominant clients might show more body movements or motor activity, not because of the actual pathology that might be behind it, but because of the high demand placed on expressing themselves in a second language. They may experience or exhibit long pauses and speech disturbances, such as stuttering, mispronounced words, and repetitions. They might use English words that have less meaning and emotion associated with them as a function of the vocabulary accessible. And they might also experience a different sense of self in their first language, Spanish, as compared with their second language, English. And primarily, research has found that individuals in the context of clinical interviews can show greater affect or emotionality in their dominant language. And affect has been defined in prior studies as depressive or anxious emotional indicators. So that, suggests that more emotion is expressed in the language in which the emotional event might have occurred and was encoded into memory, as we'll talk about in later slides. And we might see a pattern of minimization of emotion as well when we receive information via an interpreter. So an interpreter will provide us with an English rendering that's far less extensive, includes no emotional arousal. You don't hear the words spoken with the same level of emotion that the client used prior to translation. And so this might make it difficult for us to determine what's associated with actual symptomatology and what's associated with the nuances of first and second language use. And so for these reasons, experts have recommended to obtain some level of details on the individual's linguistic background and describe the implications of such on the data comprising the report and opinion. So working with bilingual individuals adds another level of complexity, and there can be massively varying rates of bilingualism. So it's possible for people to speak another language with fluency without understanding kind of the nuances of culturally based nonverbal behavior. And we've also probably had a situation for those of us that have worked with interpreters where the client kind of moves in and out of languages and they might directly relate information to us in Spanish and bypass the interpreter. So in general, ethnic and linguistic similarity is regarded as enhancing the clinician's ability to identify kind of the cultural context of symptoms. And there's been some interesting research findings regarding the use of native versus host language in clinical settings. So I'm primarily citing this 1998 study, which is a bit dated, but it's a very well done study that found that ethnic and linguistic matching resulted in clinical judgments of more severe psychopathology, and Hispanic clinicians rated patients as more severely impaired than Anglo clinicians when they were conducting bilingual, so switching out of English and Spanish, and holistically Spanish interviews. So this is interesting when we think about our clients expressing more pathology in their native language or our non-linguistically matched clinicians missing important symptom-related information. And specifically, more cognitive or greater cognitive problems were determined to be present if the person was speaking in their non-dominant language. Greater emotionality was rated to be present in the dominant language, so higher rates of emotional problems were diagnosed. And then in bilingual interviews, both findings were true, and these were the individuals that were rated as most impaired. And so this is important when we think about how language use can be related to symptom presentation, and particularly if we're looking for symptoms of cognitive dysfunction or emotional dysregulation in certain forensic contexts, such as competency evaluation. Other factors determined to be relevant to the evaluation process have been an appearance of understanding. So appearing more fluent than one really is, thanks to memorized stock phrases that can conceal gaps in understanding. And in forensic evaluations where, one's knowledge of a concept must be assessed, keep this in mind. And this just goes to show why it is important to have folks repeat in their own words any concepts taught to them. Disembodied cognition goes along with kind of the next bullet point of dual self-representation, but is really talking about the fact or the idea that foreign language provides a greater emotional and cognitive distance than one's native tongue. So when we're gathering information directly from an individual who's speaking in their non-dominant language, consider this, particularly in forensic settings. For example, if we're eliciting one's version of an offense narrative or events in terms of like conducting risk assessments or in sex offender treatment, it's important to notice this when an offense narrative is part of the process, particularly if we're looking for indicators of remorse or understanding or emotional affect associated with their account. Dual self-representation. So languages spoken by the client can have that detachment effect, and people can have different self-perceptions based on what language they're using, which goes back to those findings that if an emotional event was encoded in memory in one language, it's more easily retrieved from that language where that kind of mental representation exists. And let's consider too the clinical formulation and diagnostic process. So research has emphasized this dichotomy between over-pathologizing behaviors, so mislabeling religious themed beliefs as delusions among different cultural groups, or labeling mistrust of the legal system as delusional, even though it might reflect, true experiences with corruption in legal systems in the US or outside of it, and mislabeling spiritual cultural experiences as hallucinations. So as a quick aside, as a graduate student, I worked in central booking in a jail, and we would often do kind of quick triage assessments for mental health symptoms just to determine housing. And I would ask, do you hear voices? A few instances, I had some monolingual Spanish speakers endorse hearing voices of grandmother or family members. But upon probing, this was more so kind of an inner dialogue, and particularly if they felt ashamed for being in the booking process, they disclosed hearing voices or hearing kind of phrases or words or guiding dialogue or shaming dialogue from family members. And the other end of the spectrum is normalizing behaviors. So recalling the finding from Varela and colleagues that Spanish-speaking individuals were less likely to be referred for competence to stand trial evaluations. Some of the hypothesized findings were that, or the reason behind the findings, were that attorneys perceived Spanish speakers as less mentally ill, possibly as an overcorrection to avoid mislabeling them as ill. And it's possible too that they missed mental health symptoms due to language barriers. But this kind of overcorrection effect, we can think about it. If someone is attempting to be more strengths-based or culturally competent and avoid the deficit model, they may have considered the statements or behaviors of the individuals as non-pathological in an attempt to do so. And, we see how language influences the provision of information as well, in that the use of Spanish by Hispanic bilingual patients resulted in more symptom endorsement than interviews conducted in English, similar parallel to the findings we discussed in a previous slide. But nonetheless, something is going on here with regard to the labels that we're placing on the information based on the source and the language of the source. And when language is really our only means of gathering symptom-related data, it becomes even more difficult to recognize accurately the presence and severity of mental illness in the absence of gross behavioral abnormalities. So thinking about delusional disorder, when the person presents as quite high functioning besides what they're relating, it can be quite difficult to make sure that we're getting accurate information and not just relying on different modes of communication here. And when the presence of mental illness is less certain, and when there's an ambiguity regarding the client's psychological functioning, we might rely more on some of these differences in language. So when, the person could go either way in terms of our opinion, language factors might play a larger role in the ultimate opinion. That could be either ideas we have about language, culture, expressed emotion, or what's considered normative or cultural. But needless to say, these factors can result in imprecise diagnosis at best and misdiagnosis with dire consequences at worst. So when we talk about our role, again, as forensic examiners providing information regarding clinical characteristics to the court, is language a clinical characteristic that we as mental health professionals and not linguists should bother with, or is it outside the scope of our work? Clinical characteristics traditionally refer to extreme mental or emotional illness or distress in a forensic mental health context. So is language a clinical characteristic? perhaps not on the surface when looking at it directly, but the trickle down effect of limited English proficiency can absolutely impact psychological and behavioral functioning. And, moving from what we just discussed, language impacting the provision of information directly, we're going to talk a little bit more now about language, structuring life experience of the individual across the desk. And therefore, speaking directly to our clinical formulation and opinion. So let's revisit Ms. Garcia's case and recall she's a limited English proficient Spanish dominant client referred for Miranda evaluation after confessing in the interrogation room to aspects leading to charges of child neglect resulting in death. And we're going to proceed to use this case to apply in forensic evaluation context. So first, adjudicative competence. Let's think if we were doing a competence to stand trial evaluation with Ms. Garcia. So consider the source. Are the collateral sources received the result of ad hoc, mechanistic, or cultural brokerage translation? With Ms. Garcia, the jail records received consistently reflected ad hoc interpretation attempts with Ms. Garcia, even to the extent of folks gesturing at her as a means of communication. And so we had nursing staff, we had correctional officers kind of serving as interpreters, and that really affects the type of information that we were getting. No communication with her, no meaningful communication with her at least, meant no real assessment of her symptoms. And because she presented as fairly withdrawn in interactions, she wasn't drawing attention to herself or going into disciplinary, she really wasn't assessed any further. And so considering the use of collateral sources and competency evaluations in particular, these records would really reflect no dysfunction. And she was housed in a non-psychiatric unit because, again, no overt behaviors suggesting mental illness were present. And if housing status is something that you look into in terms of a data point for a competency evaluation, that could kind of bias us in the way of skewing competent. If you're looking up the client and seeing what unit they're on and you see that they're not in a psychiatric unit, that could potentially at least put the idea in your mind that perhaps they are not as experiencing as severe of dysfunction as some other clients that you've seen before. And imagine if all of her interactions with health professionals were similar. So language barriers can and do preclude receiving services, and a lack of psychiatric history might again cause us to skew towards competence. Think about her level of familiarity with the US legal system, and more than that, her familiarity with a specialized vocabulary, wherein the word plea, for example, or declaración, can have multiple meanings relevant to the legal setting. So it can refer to testimony, it can refer to statement, and it can refer to plea. If they have a familiarity with the criminal justice system in their home country, how might that knowledge eclipse what we're teaching them during the competency interview? And based on any prior negative experiences, we must determine whether, any potential paranoia regarding the legal system is normative, given their experience, or irrational. And then the functional interview. So noting the presence or absence of behavioral indicators of symptomatology and kind of looking into the research on that based on what we talked about in the earlier part of this presentation. And response style, are they engaging in any type of minimization, providing the appearance of understanding? And, for Ms. Garcia, she had a tendency to deny problems, which was paralleled by testing. And while this can be the case, it can really underestimate true experiences. So it could be the case that she really wasn't having many problems or didn't in the past, but we always want to be aware of that potential tendency. And we might, try instead to engage in some additional probing or pointed questioning to get more information. And idioms of distress, what terms were being used to convey distress? So several have been widely referenced as idioms of distress for Spanish speakers, and they tend to be kind of more physical complaints that can mask psychological distress or be a proxy for mental health problems. let's go into the Miranda waiver evaluation. So, language is perhaps most relevant or kind of most face valid to this referral question. And experts have stated that people who are LEP constitute a uniquely vulnerable group when it comes to understanding Miranda. And really few, I think, would argue with that because it is so language based and communication based. And, with regard to Miranda warnings that have been translated into Spanish, for example, it's been found that these warnings are really kind of fraught with errors, although there might be a trend now, or enough legal consequences where the translations are a bit more accurate. But, Rogers did some work in the past, over 10 years ago-ish, with some really useful articles and highlighting that determining whether the translation was at the quality standard that allowed someone to knowingly, intelligently, and voluntarily waive their rights is really part of the forensic evaluator's role, in addition to whether any mental health symptoms that might have similarly or differentially impacted this competency are present. So, looking at the three prongs of knowing, intelligent, and voluntary in the context of language, knowing refers to the suspect's ability to understand the rights given to them in the manner in which they were delivered. So, are there errors in the translation provided? Or conversely, was the person's level of English proficiency incongruent to that required for meaningful understanding of the warning as provided? Intelligent refers to the suspect's capacity to use the information about the rights to make a rational and self-interested decision. So, awareness of the consequences of waiving their rights. And research has shown time and time again that lacking familiarity with the legal system, perhaps as a result of no involvement with the legal system or not, being of this culture or watching shows where Miranda's part of the show or any aspect of the legal system is kind of part of the program, that oftentimes leads individuals to think they're required to talk to the police. So even if folks have the information mechanistically, applying that information takes another level of fluency and proficiency that might not be present if presented in the non-dominant language, or it might be skewed by inaccurate or imprecise vocabulary. And speaking English is really not an all or none proposition. It's not, black or white. There are people who can converse on a variety of everyday topics, but still fail to understand sentences with legal jargon and multiple clauses, and fail to apply that information rationally to their reasoning. Voluntary refers to whether the suspect was vulnerable to strong assertions of guilt or insinuations that the interrogators are there to help. And an example, of this might be, this threshold can be influenced by lived experience. So a fear of deportation, history with their home country's justice system, being in an isolated environment can all affect one's vulnerability to such environmental factors. And so the evaluator should report on those aspects that might make them especially vulnerable to influence by the interrogating officer, which is where language and that lived experience comes from, or comes into play, I should say. And language-wise, the approach is also the totality of the circumstances wherein forensic clinicians have to evaluate the cumulative effect of mistranslations, grammatical errors, confusing statements, etc. And the more errors there are, the stronger the case against waiving one's rights knowingly, and as a result, possibly intelligently and voluntarily. We should also be considering person-centered factors, intellectual functioning, suggestibility, oral and written language comprehension abilities, and situational factors. So how the person was informed about their rights, what was going on in the setting, what was the behavior of the interrogators. So there's a noted trend of Spanish version Miranda warnings tending to require a higher reading level in order to establish true comprehension of the content. And there are a few indices that one can use to determine reading level, but it's not a one-to-one relationship. So grade attainment, if that's the metric we're using, is not the same as grade level comprehension. We should also consider the time elapsed since the client attended school, the quality of the education received, and any decline in reading and language processing abilities in recent years. So, there's actually a trend for more information provided in English versions as well. So it's kind of less and more complex information being provided in Spanish Miranda warnings. Factors that are affecting the complexity can be high information density being delivered at kind of a rapid fire rate, more low frequency words with which someone would not be familiar with, like legal terms, complex hypotheticals and conditionals with different verb constructions. So if you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. And so we can see really how this can be very difficult to process and understand, particularly if we're in a high stress situation. It's not our native language, or it is, and there's kind of marked errors. And if we're experiencing any type of mental health symptoms as well. And so kind of piling on the cognitive resources required can be quite taxing for LEP individuals. So I'm going to talk through a little bit of what happened in the interrogation room with Miss Garcia. So Miss Garcia stated that when she was first taken to the interrogation room, the detective spoke to her in English, and she vaguely indicated she understood some of what was being said to her. So she reported she was introduced to the interrogation by Detective X, who spoke English. Miss Garcia explained she understood very little of what Detective X was saying to her, and she stated that Detective X continued to speak to Miss Garcia in English on several occasions, despite Miss Garcia having asserted she could not understand. Prior to the Miranda warning, Miss Garcia asks Detective X if she speaks Spanish, to which she replies that she does not, but she does have Detective Y available to assist in translating if needed. She also instructs, Detective X also tells Miss Garcia she will speak to her in English, though asks Miss Garcia to let her know if there's something she does not understand in English, and then Detective Y can translate. Detective X otherwise instructs her to respond as best she can. She asks Miss Garcia in English whether she understood this, to which Miss Garcia appears confused and looks to Detective Y to translate, which he does. Detective X again asks Miss Garcia if she speaks English, to which Miss Garcia replies she understands a little bit, but cannot understand anything right now. After this exchange, Detective Y begins attempting to translate for Detective X. Detective X tells Detective Y to tell her if she's going too fast for him to translate, to which he agrees. He introduces the interrogation. However, this translation is not exact. So, for example, prior to reading the Miranda warning, the following translation is provided to Miss Garcia. I'm going to leave this up for y'all to read while I continue. Miss Garcia recalled that when Detective Y began translating into Spanish, Detective X, the English-speaking detective, would speak in very long sentences, but the Spanish translating officer, Detective Y, would speak in much shorter sentences, suggesting he was not directly translating her words. And she identified the same concerns when Detective Y translated Detective X's statements to the female detective in English. At one point, Ms. Garcia attempted to end the interrogation, and the detective stated in both English and Spanish that it is her decision, though they cited that it's important for Ms. Garcia's son that Ms. Garcia tell the detectives what happened. Ms. Garcia states she does not wish to speak about the events any further, and Detective X, the English-speaking detective, tells Ms. Garcia she can't leave yet and offers that Ms. Garcia can put her head down for a few minutes and rest, though there are still other things that they have to talk about that are really important. Detective X asserts that she, Detective X, still has to do her job today, which entails continuing with the investigation. Ms. Garcia proceeds to ask the detectives if she's under arrest, to which Detective Y responds she's not under arrest, but rather detained. And she continues with the interrogation. So, in this last piece, we can really see the cultural and linguistic disconnect in terms of Ms. Garcia's understanding of the circumstances. Her behaviors and actions suggest that she might have been overly compliant or acquiescent to the detective's encouragement to continue with the interrogation due to not fully understanding her rights, the gravity of the circumstances, or assuming she could get in more trouble if she refuses. So let's move on to mitigation and sentencing. And I'm keeping an eye on time, but I think we're doing okay. So, this was not a mitigation evaluation, but I did want to consider how some of these factors mentioned earlier could pertain to mitigating factors. So mitigating factors during the sentencing process are particularly apt for us to consider linguistic factors or cultural aspects of the individual more broadly. And mitigation evaluations allow we examiners to really go beyond the mental disease or defect predicate or beyond mental or emotional distress, meaning that there are various avenues we can take to explore mitigating factors that go beyond clinical factors. And mitigating factors tend to be broadly framed across jurisdictions, though with some variation, but they typically invite clinical participation in this area for those of us that have done mitigation or sentencing evaluations. Mitigation can look into cultural variations, and that's really important in the sentencing context. We can look into extenuating circumstances at the time of the offense. So this person in this frame of mind, in this environment, with this background at this particular time. And Melton and colleagues, went as far as to say that examiners can explore features of identity and self-concept that reflect culture-linked beliefs and fill out their social context with an eye to grasping offenders' moral views or reasoning processes. So how does language impact the social context? If we take, again, kind of a social constructivist view, how has language allowed the individual to access or not access areas, privileges, and opportunities? So going back to Miss Garcia and her childhood and history, she was someone who was isolated linguistically and otherwise. And if language is the key to opportunities, to contact services, privilege, not being granted access could help explain how things really got to a place of disaster for her. She came to the US as a child in a relationship with an adult abusive man, and for many years, she really didn't have a means of escape. She gave birth at a young age. She was prevented from attending school, and we don't really know what the quality of her education really was. During the evaluation, she made a statement that she didn't want to be in the United States. It was never her dream to come to the States, and she followed her husband, and all of her experiences in the US were pretty negative. So she didn't want to participate in the culture here, and it makes sense kind of given the circumstances under which she arrived. She was reluctant to engage in the community. She kept herself cloistered, besides with close family. And reasons behind this were, her immigration status, fear of deportation, cultural beliefs, and similarly, some post-traumatic vigilance. And so there was really a low frequency with which she ventured outside of her area. And this can help explain how these individuals that we come into contact with are kind of able to fly under the radar for so long until something, horrific happens. Her limited experience was really what she knew as a child, and that was more survival in Mexico. She lived a similar mode of survival and relied on her children here to care for themselves and for her eldest disabled son, which was really not appropriate or possible given his needs. And then given her history of good enough translating in jail settings, it might be possible to extrapolate to other healthcare or attempt to receive services. So how would her life have been different if she did receive the services she needed, particularly with regard to parenting, education, and assistance? But overall, her limited English language skills impacted her ability to participate in her surrounding environment, which was compounded by trauma-related avoidance and kind of this worldview indicative of mistrust, vigilance, and overcoming by oneself. So taken together, these are all important cultural considerations when thinking about Miss Garcia's ability to function in the world around her and circumstances that might speak to mitigating factors. So wrapping up, we're really limited in terms of the information that we receive and can use with regard to Miranda warnings, and working with individuals who themselves are systematically disadvantaged in forensic contexts by limited information. So barriers to full testing batteries, even when referred to evaluation, they might be getting limited information in terms of their circumstances or their status in the legal process and receiving treatment and services. And diagnostic differences and errors can and do arise from cultural differences and styles of communication and interaction. And this is really important to remember when we're working with interpreters. We're receiving the translated account that might be disjointed from emotion and nonverbal cues. And it's kind of up to us to put all of that information together to inform our clinical conceptualization of this individual. So it's taxing for us as well, but important. And, remembering the healthcare disparities exist. So these folks might have a lack of treatment, diagnosis, and resulting collateral records don't mean that this person has no history of symptoms, but perhaps that their symptoms were misdiagnosed, or ignored due to logistical barriers. So we can really do better as forensic examiners. We can give due attention to the lived experience of the individual across the desk from us, and specifically the consequences of being unable to participate in one's environment as informing aspects of clinical formulation. And hopefully some of the examples provided today can kind of illustrate that. And, just final words, that we're more than circumscribed diagnosticians. So we might feel a little bit of discomfort going past directly related mental health factors when forming an opinion. But in reality, many of our referral questions call for comprehensive conceptualization of the individual beyond just general diagnoses or what we're observing in this psychological realm. And our goal is really to gather, process, interpret data, and present a cohesive opinion to the courts in a meaningful manner. So ethically, we really have a role and an obligation to help avert misunderstanding regarding the person's demeanor and explain, various client presentations to the court or other lay audiences in a data-driven manner. So I don't have like a great ending statement, but I do hope this presentation, might strike a match or light a fuse in terms of thinking deeper about linguistic factors in forensic work. And I look forward to any questions that I hopefully will be able to answer.
Well, thanks so much, Emma, Dr. Hamilton, for not just talking about this issue, but showing us and illustrating how how this can present in the work that we do. I'll give a caveat as questions continue to come in, that I anticipate some of these questions seem to come in right around the time that you actually then ended up addressing similar issues. So I might still throw them out eventually. Anyway, it's an opportunity to perhaps either just elaborate on those or just reiterate some of the points that you've made. So one question was about, somebody said, I've noticed that in conducting competency evaluations with Spanish-speaking defendants, many have difficulties engaging in discussions about the legal system more abstractly, separate from their own specific charges or case. Oftentimes, we need to discuss the legal system in a general matter in order to assess their capacity to understand. And so this person wanted to know, what are your experience or thoughts regarding that specific phenomenon?
Well, not even, that's a great point. And not even just with Spanish. Actually, yesterday I did a competency evaluation and it was similar. It was like asking more hypothetical or general questions. And the person really couldn't get outside of their own experience in terms of offering explanations or opinions. But I do think that happens quite frequently just across the board. And I think, at least we can try to make some efforts to explain the purpose of the evaluation, because it's really a novel, kind of strange interview process in terms of it being, I've had a lot of folks say it's more like a quiz, or we're testing them and such. So I think you can't go wrong with over explaining the purpose and the format and the outline of the functional interview for competency. And making sure, at least trying to make sure in the limited time you have that that can be understood. So, saying, I recognize that this was your experience. What would you say to someone in a similar position? Or what would you say to a brother or a sister going through this? How do you think they might explain it, or things like that? So, yeah, and if there is kind of a lack of abstraction abilities, it could also speak to cognitive functioning as well. So I think that's a really good example of kind of putting the onus or putting all of the observations on the language, and is there something deeper going on that's affecting that lack of ability for abstraction? Because if we observe that with English speaking clients that were, or defendants that were evaluating, would we have similar factors like, oh, is this an English speaking thing, or is this something deeper where they can't engage in that type of abstraction or higher level thinking? But that's a great question. I've
Yeah,
observed that as well.
certainly, certainly. Um, how would you suggest we account for bilingual evaluees' stated preference to interact in English? And this person had a specific example where they just met with someone who insisted to receive all the services in English. The evaluator offered a couple of times to have translators available, and also said it might be easier to explain their thoughts in their first language. But this person who presumably English was their second language insisted and said, I would prefer to interact with English. How do you deal with that?
Yeah, so that's that's another great kind of question or situation. It's like we want to respect, their preference in terms of what language or what mode they would like to receive services or the evaluation. But I think it sounds to me, without giving a direct advice, that you kind of did your due diligence and offered the option for an interpreter. But I would just then be cautious and keep an eye out if you think that there are misunderstandings happening. And I hope some of like the research cited today can show how, if we are receiving information in someone's second language, how that might present as having less of an emotional valence, for example, or they might present as appearing to have greater cognitive difficulties because they're going through all of the kind of mental processes that involve translating and back translating. So I would just keep an eye out if you're noticing anything like that. And then perhaps, if that were to be the case in the future, they might be more open to having an interpreter if they're encountering any more difficulties in conveying their experiences. But I think we too have a duty to respect and defer to what the person prefers and wants. And we can always put that in our report, maybe as a footnote, but we can always put that in our report or explain the efforts that were taken to provide those services in another language. I'm glad you did offer that and that you do have those resources available if they should want them.
Well, speaking of the resources available, what do you do when there are no tests available in the client's native language and no known local evaluators who speak that language? And this evaluator's experience was specifically having trouble finding for a Polish-speaking individual tests available in Polish, or evaluators who could speak Polish. How do you address that?
Right. That's what's so challenging. And again, I think folks have stated it's really ideal to have someone who's able to, speak the native language in the evaluator role, but it's really not possible oftentimes. So, I think in that case, I would try to do some research and see what sorts of language-free tests are available, but I would really be sure to illustrate that and highlight it in the report and explain in detail how that might have um, impacted the results. And then I also think that's where it comes in to do a more comprehensive look into that person's language, how it's impacted their ability to interact with their environment. If we're experiencing it right there in the forensic evaluation setting, think of how difficult their day-to-day life is and how that might have impacted, why they're being seen in front of you. And so I think doing a deeper dive into their language experiences and their language background can really help supplement some of the limitations with regard to testing there. But I know it's something that's really tricky to deal with, and I can commiserate for sure.
Yeah, and I'm actually going to jump back to your discussion before about the issue with preferred language versus for people with English as a second language, because we had a couple of people that elaborated on that as you responded. We had one person that noted that they'd been in a similar situation and told the person that they'd like an interpreter for their own understanding as an evaluator, and that in that situation, at least, that person seemed receptive to that. And then we had another elaborative thought that somebody got pushback on asking for a translator because for those that had received restoration in English, because the idea would be that their competency restoration experience that was in English is inconsistent with your evaluation that would be in another language. Would this be a concern? And how do you deal with this, basically this disconnect between competency restoration in one language and perhaps evaluating somebody's competency abilities then following up in another language?
That is so complex. I have to say I'm not quite sure on that situation. I haven't dealt with it, but it gets back to kind of this dual self-representation where, one person, they might be competent in one language and not in another. So I think in that situation, I mean, that really does present something interesting. But if they did receive that competency restoration in English, I would, I might try to do an evaluation that gets at both. So is someone able to convert that knowledge learned in one language to another language? So, yeah, I think I would try to do kind of if I could, if it was available to me, I would try to have an interpreter there and be able to assess their language or assess their understanding in both languages. But that's definitely an interesting point. I know it's kind of tricky. I worked at a state hospital and there really weren't any Spanish competency restoration services being provided. And we started those, but the person, I'm thinking of one person in particular who had been receiving kind of that knowledge in English, but didn't really have the basic level or mastery of language that would allow them to kind of understand and really, incorporate that knowledge into their reasoning. It was just it adds a lot of different kind of nuances and difficulties there. So that's a complicated situation, is the best I can say, I think.
Yeah, it certainly is. I think gets back to what we're assessing, how much they actually learned have retained versus their capacity to understand and appreciate, and different language issues having implications for those two sides of the coin of competency.
And I would I mean, these are all areas that are desperately in need of research. So if there's anyone on the call here, any graduate students or anyone going through dissertation, I mean, I think this is really a good field. The Varela and colleagues, article, I think is seminal in terms of like working with and how Spanish speaking individuals are differentially treated in the forensic system. And I would love more articles in that vein.
Sure. We have one question from someone that says, as a native Spanish speaker, I would love to conduct Spanish language forensic evaluations. However, as you mentioned, everyone has different levels of fluency, and this person personally doesn't feel comfortable with their fluency, specifically of legal terminology. What are your recommendations on how evaluators can increase their foreign language fluency in specifically the legal and mental health areas during evaluations, as opposed to more broad language fluency?
Yeah, absolutely. That's a really good point. And I think for me, I feel similarly, and I was not really able to work on my vocabulary. And again, I'm really not perfect by any means at all. But when I was working at the state hospital and we were kind of developing and adapting a competency restoration program and then utilizing other information that, or other programming that we had access to, I'm not quite sure where it came from. But having that experience, and I would be happy, take down my email. I'd be happy to share whatever resources I have, but being able to kind of teach that week to week or multiple times a week to the the individuals in the group really helped bolster my vocabulary. And I'm still learning. Like there are times where I'll explain something to a Spanish speaking client and they're like, oh, I think you're talking about this. So again, we're going to be dealing with folks with very different dialects and ways of interpreting language. And especially, I mean, even with English speaking evaluees, I constantly have to explain what a plea is. Like, so in a competency evaluation, it's like, what are the pleas that you can enter in court? And a lot of people don't know that, even though that's really the word that's used pretty universally. So again, it's, I hope this is an okay stance to take, but it's kind of a constantly evolving learning process on which words might be more well received or understood by the person in front of you. So just like how you do already, you're kind of modifying your interview as you go, or trying to like explain things a little more directly or concretely. I think that it'll just be an evolving process, but I also really appreciate it. I mean, I think your self-reflection is good, and I bet you would be great in doing those evaluations anyway.
Always offering encouragement. It's wonderful.
Yes.
Yeah. This one's a rather direct question. So just get your thoughts on responding to this idea. Can a language barrier alone constitute incompetency to proceed?
Well, I guess it depends on what is the competency standard in your area or in your jurisdiction. So actually in New Mexico, we really don't have a, mental disease or defect predicate. So technically, I suppose in a certain circumstance, and if you had a case that was kind of perfect for that scenario, or really fit that scenario, I guess you potentially could, if it involved with communicating with one's attorney or rationally understanding their circumstances, et cetera. But that would just depend on the jurisdiction. I have not personally run into a case where language alone impacted competency, but I have done Miranda evaluations where there really weren't any major cognitive or major psychological factors at play, and it really was just language based. And that's where we really kind of set the stage and explained how this person's language abilities has impacted where they got to today and how they acted in the interrogation room. So I hope that's helpful. I haven't run into a case. I'd be very interested if someone has and how they talked about it, but I guess it depends on, your competency standard where you are practicing.
Sure. Okay. One last question I'll throw your way. Sorry, we could not get to everybody's. But do you have any advice regarding competency restoration for individuals with limited English proficiency when it's thought that perhaps they have delusions that could partially be based in cultural aspects?
Oh my gosh, I know. So this is the interesting piece where parsing that apart can get tricky. And we have to really watch ourselves too, where it's like, I think this, getting back to the definition of a delusion, the rigidity, the inflexibility, the fixed thinking, even when confronted with information to the contrary, is where we have to kind of get at, is this a delusion versus is this part of like someone's cultural background? And this goes back to when I presented, on gang stalking, and how, I don't know if anyone was there, but anyway, how, if a delusion or belief has this like shared nature, it's automatically not a delusion if it's like shared by others in the cultural group. So yeah, I have to say my expertise is not really competency restoration, although I have I provided competency restoration classes before as a graduate student. But I think for that, I just would recommend kind of parsing apart and getting as much information as you can about whether this is more of like a normative cultural belief, or is this really impacting someone's functioning at the level of a delusion would. That's kind of the best response I can give. I'm sorry it's not better, but I do think that is something that comes up quite frequently when we work with people from a cultural background, and we have to kind of watch ourselves in terms of what we're judging to be delusional or not. So, for example, I'll give a quick example and then I know we're done. But I just had a individual I was working with who was convinced that the corrections officers were poisoning his food. And then, upon doing some digging and some collateral interviews, it turns out that he had that experience. And that was actually quite verifiable in his home country when he was locked up. So to me, I was like, this is, probably in the delusional realm. And it turned out it could actually was within the realm of possibilities. So just an interesting aside.
Always doing your diligence to confirm those reports, even if they seem unusual or even bizarre. Yeah,
I know, and even in this day and age, who knows what's going on sometimes. So,
yeah. Well, Dr. Hamilton, thank you so much. This I'm sure this proved enlightening to people around the spectrum of language proficiency. We got several people that near the end were offering their email to inquire about issues further, discuss more issues. I've done my best to copy those for you for future reference. For those of you that wanted to reach out and contact more, I hope that I saved it correctly, and I assure you I will direct those to Emma in no time. That is a wrap up for this week's Law and Mental Health series. We hope to see you again next week with Dr. Alejandro Leguizamo talking about cultural issues around sexual aggression. Have a fantastic rest of the week, and we hope to see you next Tuesday.
Thanks, everyone.
Thank you.